we have got Vincent Howley. We've got a fantastic panel today. We've had a really great sign up for this. We've got 120 people signed up for today's session. As you all know, if you've been in this before, the session is being recorded. So if you do have to drop off or go on a call or what have you, don't worry. I'll be sending you the direct link to the recording, and we'll be putting the session on our YouTube channel. It's this is a very important topic, and I think we were just talking before going live. It touches everyone in some way, but the members of the mobility industry, cybersecurity is vital. You are handling such sensitive data. So the aim from today is to introduce you to these three amazing people who have experience, expertise in the field. So I'll just wait for a few more people to come in. Like I said, we've got 120 people signed up. But obviously we know that normally only half that will join at any given time, because you'll all get the recording. So I will just make a very quick point. Ronald, while we've got you here, for those of you who are coming to Villamora, if you haven't checked out the travel section on the app that Ronald's colleagues and his team have put together, you really must, because it's a fantastic resource. Thank you ever so much, Ronald. It's been great. Clivia, thank you to everybody putting notes in the chat box. That reminds me to say hello from Bean, hello Marion, hello Andreas, hello Sylvia, hello Clivia. If any time we've got a question, please put it in the, hey Inigo, how are you? Please put it in the chat box. I will keep an eye on that throughout the session. I'll try not to interrupt, while our brilliant panelists are speaking, but in the interim points, I will raise any questions that you have, and obviously at the end, we'll make sure that we've got, I'll make sure that we've got time at the end for Q&A, of which I think there will probably be quite a lot. So without further ado, I'm just going to do a share screen. So for those of you who know Zoom well, it will suddenly just take over your entire screen. In order to just bring it down to normal, just press escape. And that should work. Right, so I am going to do this. We've got a PowerPoint from Gordon. I will share that. Can you see that? That's worked okay? Yes, good. Mm-hmm. So, Gordon, thank you very much indeed for starting this off. I will just introduce our fantastic panel. So today's speakers, we have Ronald Hooskamp, who is the founder of Relocation Online and definitely an expert in the field. We have Gordon Kerr, who, as you know, is our strategic consultant for legal services, and again, has researched this topic extensively over the years as part of our GDPR guide and our legal contracts guide, both of which are available for free on the website. So if you need a copy, just go to the website, go to publications. And Stuart McAllister, Managing Director at Interrelocation. Stuart, it's great to have you with us as well. I know you've got some real life experiences to share, which will be very interesting. So Gordon, without further ado, I will hand over to you.
Thanks, Dom. We've split this into three sections, and each of us is going to cover one of these sections that you can see here. I'll start with the legal side. What are the legal obligations that every business has in terms of protection against cyber threats? And I will then pass on to Ronald, who'll look at the technical and organizational things that we should all be doing to protect our businesses against cyber attacks and accidents. And then we'll pass on to Stuart, who'll talk from practical experience of surviving an attack and things that now occurred to him about how best to protect a DSP business at a very practical level. So if we start with, let's start with a definition, because cybersecurity is one of these very vague terms, but it's all about protection. And we're protecting two things, the information and the data that all our businesses store. And we were joking earlier that, in fact, if we still stored things in paper files, there would be no such thing as cybersecurity. So we're not talking about paper files here, we're talking about electronic data and information that all of us rely on. And the second aspect of that is we then share that data, we use communication networks, and in both these settings, we need to protect against any form of unlawful use, whether that's as a result of accidents with, carelessness by an employee, human error, or whether it's as a result of a deliberate attack by cyber criminals. So if you could move on, Dom. Yeah, I thought it's worth just highlighting, why this is such an important topic. There are several reasons why this is really pretty near the top of the agenda for so many of us. Firstly, the fines that are imposed by the national regulators, such as the ICO in the UK, but every European country has its regulator, and these regulators are entitled to impose fines. And we'll be touching later on some examples of these fines, but we're talking about multi-million pound, dollar, euro figures. The second thing that we shouldn't lose sight of is that every time that we enter a contract with a client, so that client may be a relocation management company, it may be a corporate client, there will be clauses now in these contracts which put an obligation on a DSP or whatever supply you provide. There will be obligations to protect the data that you hold in your systems or that you have access to. And if you fail to comply with the obligations in that contract clause, then you're open to a damages claim from your client, as well as, in practice, losing the client, of course, for failing to comply. Individuals who are affected by a loss of data can also make a separate claim against you. So if you lose the data of several hundred employees of a company who you're managing the relocation for, then each one of these individuals can make a financial claim against your organization. And if all of that wasn't bad enough, there's also the fact that you've just trashed your reputation. These things get out there, and of course, if anything is a damages claim or a fine by a regulator, it's in the public record. So your reputation is badly damaged by it. So 4 very good reasons why this is a very important topic and why it's important to get it right. So let me just move on then to what the law says. And as with everything in Europe, it comes back to our friend, the GDPR. And as many of you will know, there are some fundamental principles under the GDPR. And one of these is in terms of data security. It's important for every firm that handles data in Europe that they have in place appropriate security, protection against unauthorized loss, accidental loss, and that they have in place appropriate technical and organizational measures to protect data. So it's a very general statement, and we'll be looking in a little bit more detail about what that actually means. But I think a point worth making here is that the GDPR doesn't say this is what you must do or this is what you mustn't do. It's all about appropriate steps, depending on the type of data you have, depending on the cost of protection. So you're allowed to have a perspective on this where you take appropriate measures. There's not an absolute thing such as, requiring encryption in all cases. It's appropriate. So let's look in a little bit more detail under the GDPR. And Article 5 goes into just the next level of detail, which explains that whether you're a controller, a data controller, or a data processor, you're under an obligation to put in place these technical and organizational measures that are appropriate. And this is what Ronald will be talking about in practice, but we're talking here about things such as antivirus software, as as an example of a technical measure. And organizational measures would be things like staff training, handbooks, having policies in place. And then that in turn within the GDPR is followed up by, I think it's Articles 32 and 33, Dom, if you've got the next slide. Otherwise, I need to remember what we're talking about here in terms of GDPR clauses, which is way beyond me. So Article 32 of the GDPR, again, just drills down a little bit further and makes this very key point that the required level of security has everything to do with the kind of data that your organization holds and processes. And if you hold, for example, information on health issues or financial information, say credit card details of an individual, then the expectation is that you will have in place controls that would be at a higher level and more stringent than an organization that just held names and addresses, for example, just pure contact details. And if we move on to the next slide, yeah, this then is saying, well, what if we have a breach of data security in our organization? What does the GDPR say we have to do about it? So the first thing is that usually if you're a DSP or other supplier to an RMC or to a corporate client, usually you would be the data processor and you have an obligation to notify your client in their capacity as the data controller. So that's the first thing. You've had a breach of data, you're concerned about it. Well, the first thing you do, let your client know, let the data controller know. Now, there are two other possibilities here in terms of having to notify a data breach. The first would be to the regulatory authority, such as the ICO in the UK. The ICO say that they probably 90% of the breaches that are notified to them don't actually require to be notified, because what the ICO are looking for are cases where there is a risk to an individual's rights and freedoms. So if you lose some data or you send some data to the wrong place, but actually, while it's embarrassing for you, it's not actually damaging to an individual's rights, then there is not a requirement to notify the regulatory authority. Having said that, it's understandable, if in doubt, obviously, your business would report the matter just to avoid any accusation that you had hidden the breach or it was a breach that should really have been notified. And there is also potentially a requirement to notify the individuals whose data has gone astray. But here there's an even higher level, and it's only where there's a serious risk to that individual's rights and freedoms. And we'll move on to look at some examples of that. What does that really mean in practice? Now, obviously, for our industry just now, there's huge concern when we heard of the problems that Serva had encountered. That started as what we call ransomware, where you have cyber criminals obtaining access to an organization's IT systems. They deprive you of access to your data and will only release that data if you pay a very large sum of money to them. And this is such a common crime at the moment. But the Serva case, which is actually in the Canadian courts at the moment, is I guess a warning to everyone in our industry. And at the moment, that's a very serious action, court action against Serva, suggesting that they didn't have in place proper measures to defend against a cyber attack. But as I say, that's in court, and that may or may not turn out to be the case. It may be they've done everything possible, and the cyber criminals still managed to breach the security they had in place. There's a second aspect to the case, which I think is kind of interesting from the point of view of relocation companies. There's also a suggestion that some of the data held by Serva should already have been deleted from their systems. So you'll recall that the GDPR, one of their principles is you should not retain data for any longer than is required for the business purpose. And I would say, certainly among relocation management companies, it's typical to hold data for, say, 7 years. And one of the factors in that is that you may be holding financial data which may be required for tax purposes. And often tax records have to be kept for 6 years. So you say, right, we'll keep everything for 7 years just to cover ourselves. But if you weren't holding information for tax purposes, and let's just say all your services were simply home search and orientation, then you would almost certainly should have in place a shorter period before data is deleted. So in this case, and again, these are allegations against Serva, and they may or may not turn out to be correct, but the suggestion is that they were holding data for longer than was necessary, and that made the data more prone to attack. There was more data to capture. At the other end of the spectrum, there's a current case in the UK, which is the Manchester United case. And this was accidentally sending some data to the wrong people. In this case, it was some employee data, but it did include pay information, and it was sent to some outsourced staff. Now, Manchester United discovered the problem. They reported it, self-reported to the ICO, explained what they were doing to avoid this ever happening again. And the ICO were completely happy with their response. So no fine, but the employees who were affected decided that they would sue for compensation. And that's in the UK courts just now. And in fact, the amounts are relatively small. Again, was there any serious damage done to these individuals? Probably not. But you have over 100 employees all claiming, and I think the average claim, it's only about £3,000. So you wonder why a club like Manchester United, which pays £80 million for a footballer, hasn't just paid out on this, but they must have their reasons why they weren't prepared to. So that's in court, but it is an example where even if the regulatory authority says, yeah, you've done everything, that's fine, the individuals affected have a separate right of action and can claim compensation. And the other one I wanted to mention, because it was such a huge case a few years ago, this was the Marriott Hotel Group. And it sounds initially that they were unlucky. They bought a hotel chain in 2014 called Starwood. And so they bought the chain in 2016, but Starwood had their systems breached 2 years earlier, so in 2014, but were unaware of the issue. So, this information was being collected by criminals on everyone who was booking in with Starwood and then later with Marriott. And it took Marriott further 2 years, 2018, until they discovered the problem, and then they immediately reported it to the ICO. And what the reason they were fined so heavily, well, firstly, the huge amount of data had been scraped over these 4 years. But also the court said, or the ICO said, when you bought Starwood, you were under an obligation to carry out due diligence. You should have been checking what systems they had in place, and that would have disclosed that their systems were inadequate. The initial fine was actually £99 million, but it was reduced on appeal to 18 million. But that does show, that extreme end. If things go wrong and over a period of years you just don't have systems to detect a problem, then the authorities are going to take a pretty dim view of that. So I think with on that happy note, it's appropriate to pass on to Ronald to find out the kinds of things we should be doing then to avoid these disastrous legal scenarios that we can fall into. So over to Ronald.
Thank you very much indeed, Gordon. That is fascinating. Ronald, I will just pass you the host and then you can share your presentation. Okay.
Thank you.
There you go. It should be with you momentarily.
There we go. I didn't actually realize this was a bookcase competition.
I know, I just saw Sylvie's comment. That's a really good comment, Sylvie.
All right, so technical and organizational measures. This term, as Gordon just referenced, actually originated in the GDPR, even though the underlying concepts of protecting data that is being processed by you on behalf of your customers has been around for some time. Quick note up front, there is absolutely zero chance that in the next 15 or so minutes that I have, we can do a comprehensive deep dive into all the technical and organizational measures that you should have in place. So the idea is to touch on this a little high level initially with some context for the frameworks that are underpinning much of this, help you understand where you need to start in terms of assessing your risk, and then providing a few practical examples on measures that you should have in place. Again, Gordon referenced this already. There is a distinction as well as an overlap between technical and organizational measures, also referred to as TOMs. The technical are what you would expect them to be. They are tools and solutions that you have in place to, for example, encrypt data that sits in a database or in a file, data that you anonymize because you no longer need it, or to protect your firewall from outside actors trying to get in and gain access. Organizational then is all about policies and procedures. You'll be documenting a lot of this and writing a lot of policies. Most of you already have, and if you haven't, then we'll make some suggestions for what you should at least have in place. And that includes annual actions that you take, for example, to do a vendor assessment and incorporate it in your vendor management plan. An example of perhaps measures that cover both technical and organizational would be data minimization, right? You can have, on the one hand, restrict data to be collected in systems through the system itself, and have policies and procedures in place where you agree as an organization what data you collect in the first place. And again, the whole point, top right here, training and awareness, is for you to document this for raising the awareness among your team, including the independent contractors that you work with, for internal training, but also externally, so you can demonstrate your security and compliance posture when your customers ask for that. And as they do, you've all been on the receiving end of those fun security questionnaires. By the way, quick shout out here to our friend Dal E in the AI department for generating all the images in this slide deck. The questionnaires, a lot of the language used in both some of the legal constructs that Gordon referenced in GDPR can be traced back to the security information frameworks that are commonly applied around the world. So that's ISO 27001, SOC 2, and NIST. Most of these underpin the questions that you get and the language embedded in it. And oftentimes, frankly, they're broken down into sections that you, as you've filled in these questionnaires, will begin to recognize. So taking a closer look at as ISO as an example, there's a 23, 24 some policies that make up the documentation that's required for certification under ISO. It is a lot of policy writing, and admittedly, ISO actually is more focused on the organizational aspect and a lot less prescriptive on technical measures, which is exactly what the GDPR says as well. It's all about the appropriateness of what you need to put in place. You certainly don't need to certify for ISO to demonstrate your posture. You don't need to write all these policies. We do recommend that you have about 7, 8, or maybe 9 of these in place, depending on your situation and the size of your organization. A lot of these that you see here highlighted, you probably have been asked for already in those security questionnaires, and there's a few that are simply mandatory. Data retention policy and incident response plan, for example, are required under the GDPR. You might have sort of an umbrella information security policy in place that references a lot of these, and that's, by the way, also perfectly all right. The acceptable use policy is a good example of one where you have a little bit of freedom to include things, including references, for example, to the requirement to encrypt information. Not mentioned here or highlighted necessarily is the risk assessment policy. You'll see that on the right-hand side. Not suggesting you write that policy, but it is the starting point for understanding what technical and organizational measures you should be putting in place, right? If you don't know what you have or where your vulnerabilities are, you do not know what measures to put in place. And a risk assessment, frankly, it would be wise to conduct annually. In fact, that's what the policy would prescribe and what those frameworks require. And it begins with identifying all the assets, so all the machines, the computers, the devices, and the people that touch the personal data that you handle on behalf of your customers. Map that data out. Probably categorize that data would be helpful to do, as the GDPR identifies and requires. Data classification is a requirement in that context, and so this helps you then to assign the vulnerabilities and even potentially a risk for each of those categories. And very important to you then to understand what is the impact on your organization should you have a breach, should something happen, and based on that, implement the controls and the measures that you need. And then again, document and communicate. I think that's a key takeaway for today, is the awareness and the communication internally that you have with your team to just keep at that. So a very practical way to conduct a risk assessment in terms of assets, people, and data is to just think about your day-to-day operations, and starting, for example, from the perspective of an authorization that was sent to you probably via email from your client may contain a document, and both the email and document in all likelihood will have personal data included in it that you now need to protect. You may enter that in some relocation software or CRM tool. You might add it to an Excel spreadsheet for tracking purposes. It ends up on your servers, on computers, on mobile devices. You will, of course, work with your own employees, but you will also have independent contractors and use external partners who are part of the service delivery that handle this data. Many of you still have an office. You might even still own printers. And as Gordon said, put stuff in filing cabinets. That one would be outside of the scope of this conversation, but you still have the obligation to safeguard and protect it. And in some countries, paper is actually still very much a part of the day-to-day process to get things done. Ultimately, when you're finished with the services, you may even end up putting some personal data in the accounting software when you create the invoice that references the employee that you relocated. Now, obviously, that is a tiny bit of information compared to the personal data being processed here. And if you look at this and sort of try to understand where the highest vulnerability is, spoiler alert, you will come to the same conclusion as many others have, that the weakest link in all this is email. Email, of course, is widely used by all of us, by the business community at large. So why is it the weakest link? Well, it gets disseminated across many people and devices, which makes it therefore hard to figure out where it all ended up. The data itself is unstructured, so it's hard to figure out inside the email what actually is personal data. The attachments go with it frequently end up then being downloaded to local devices, so it becomes a distribution mechanism for that data as well. And even though we all promise, yes, when we get a request to be forgotten by a data subject, and as we are required under the GDPR to then clean up the data, I think we have to admit that it is nearly impossible to find all those emails, particularly a year or two later, when even some of the people that we may have worked with may not necessarily be working for us anymore. So personal devices that may have been used, etc., all become near impossible to trace down. To back this up a little bit, and why the contention around email as the weakest link, with some data, nearly half of all emails being sent annually are in fact spam, with 1.2% of all email being phishing attacks. And while that may sound a lot less than 46%, it actually represents 3.4 billion messages per day, which is actually something like over 1 trillion a year, which is a number that I can't really wrap my head around. But it also getting a lot more sophisticated, by the way, because now AI, of course, is being used to generate these, and those messages are getting ever more convincing. So not surprisingly, depending on the year and depending on the study, easily 22% of all data breaches are attributed to phishing attacks. The top 5 rounding out the primary causes of these breaches are ransom or malware, stolen credentials, threats from insiders. We've all heard the stories about the disgruntled employees wreaking havoc, and then vulnerabilities in software. Now, keep in mind, and again, focus back on email, all 3 of the first 3 probably have their roots in email having been compromised, right? So if you think about malware, that typically enters the building through an email, somebody accidentally clicking on a link or opening a funny GIF and installing some malware on their machines. And like I said, with AI being smarter ever so often nowadays, it's harder to detect. In fact, studies show that as close as 85% of all organizations have had to deal with phishing attacks. So clear focus to then protect that email, and not just the content inside the email, but actually the email address, right? Because most of us use our email address to log into other systems, right? So it becomes our primary credential. So when that gets compromised, that's a problem. So an obvious one that I honestly hope all of you have in place, but if you haven't, make sure you do, and that is to require 2FA on all your email accounts. If your email, by the way, has a backup email on it, make sure that that backup email account also has 2FA on it, and make that a requirement for any system that you, your team, your consultants have access to log into that processes personal data. That's something you would document in a combination of your password policy and acceptable use policy. And then with regards to two-factor authentication, multi-factor authentication, Don't rely on something that is sent through email or a security code sent via a text message, because those are way too easy to compromise. Either rely on an authenticator app or a hardware version of a security key. Those you have to pay for. The authenticator apps are free, but that's important. Then there's things that you would rely on externally, like spam filters, right? Whether you use Google Workspace or Microsoft Office 365. You also want to talk to your IT department. DKIM, SPF, DMARC. Those are security protocols. You don't really need to understand what they are, but do talk to your IT team and make sure that they have implemented those protocols excuse me, on your domain, because the starting point of your domain being spoofed and being hijacked for a phishing attack is the lack of authentication of that domain, and those protocols help in that regard. So again, just pass that on to your IT team and have them confirm that this is in place. You can go a little further and start using things like a password manager, an identity provider. Those will cost money, and they can be anywhere from $5 to $10 to $15 a month for each of these services per user. So they can potentially get expensive, but they do give you a lot of control over the access that you grant. And that kind of goes back to access controls that you've obviously seen and heard of frequently in those questionnaires and in those security frameworks. It does give you a lot of peace of mind, because should somebody in your organization leave, you now have full access and control to basically disable all their logins with the flip of a switch. And a lot of those services will also monitor for unusual behavior and login access, so you get that with that as well. Bottom right, avoid email. It kind of goes back to the data minimization concept, right? If you're not using email, then of course you're a lot less at risk. And there are ways to do that. It's obviously not practical in the world that we live in, where so much of the communication that we have goes via email. But to give you one illustration, our team for the last 8-9 years has not sent internal emails. We do everything through platforms. So that covers at least all the internal communication. Obviously, externally, we do rely on email, but then try to avoid putting any personal identifying information in those emails. Takes a little bit of effort, but certainly possible. And then specific to the phishing attacks, make sure you have security training in place with your colleagues on a regular basis, and even do tests on that. And you could potentially hire outside firms to help with that. Final topic, sort of with some practical examples on data protection, because that would of course be top of the list. Again, really, I don't think enough consideration is given to efforts both technically and organizationally to minimize what you actually collect and then hold on to, and the number of people and systems and devices that you use in your organization. Within the security framework, it's all about attack vectors. The fewer attack vectors, the lower your risk profile. And then obviously some of the understandable things around access controls. That means systematically restricting user access based on permission. So you need systems that support you in that, right? Role-based or permission-based access that you can enforce that way. Encryption of data, anonymization, we talked about those before. Data retention, we mentioned a requirement under the GDPR. And then finally, practical and one that sets it up nicely for handing it over to Stuart is the value and the importance of backing up your data. So with that, Dom, I think you can take it back from me and over to Stuart.
Thank you very much indeed. Yeah, that's amazingly good advice. Thank you. Oh, yeah, there we go. No, can you, I think I have to hand it back to you so that you can take down the, that's it. There we go.
Sorry, I stopped it. Yep.
No worries. Yeah, that's really interesting. There's a couple of questions that have come through the chat, but we'll come to those in a minute. But interestingly, our email, mass email client, when you get an email from Euro, it goes through Campaign Monitor. They've been sending us things saying, you have to update your SPF, you've got to update your DMARC. This stuff has to be handed all of that over to the, and that's to basically prove that we're not spamming people the whole time, right? That's
Yep.
Yeah.
Servers can recognize that if you've set those up, that you are the authenticated owner of that domain, and it's not 100% foolproof, but it rules out the easy attacks by hackers.
Really good to know. So, like you said, talk to your provider about that. Gordon, question that I suspected would come up: are there occasions where we can become the data controllers as DSPs and also the data processors?
Not in providing the same service. So
Right.
it should always be clear in what capacity you are acting. But for example, if you're a DSP business and you get personal clients, then you are the data controller. So that's one example. But trying to think of where you've got a mix of services. If you provide an immigration service and home search services, and typically as a provider of immigration services, because of the control you have over how that data is going to be processed and what systems will be used, then an immigration provider would normally be a data controller. But your other services in delivering your home search service, for example, you are almost certainly going to be a data processor, and the controller is your client. You can go around in circles on this, and my suggestion is always agree with the client to get clarity. Don't worry about technically are we acting here as controller or processor, as long as it makes common sense, and the whole idea being that the individual whose data we're processing has absolute clarity about who ultimately is taking responsibility for the data. So that's what really matters.
So that leads very neatly onto Jeremy's second point, which is this: we've been recently awarding home finding services to a partner in another country. The corporate client is the data controller. We ask the employees to accept our GDPR clauses, but our partner is also asking the same from the employees that we've been sending for them to handle. Do we all need to ask the employees for the same approvals to share data with various third-party providers?
No, I mean, the GDPR is not intended to work in that way. The idea is simplicity for that final end user, for the individual. And if they are being asked the same question by several people in the chain, it would not be ideal. So I think the way I would look at it is, does the individual have complete clarity about how their data is going to be used, who's going to be having access to it? And provided that clarity is there, then whether the consent form is sent by the controller or one DSP or another DSP, it doesn't really matter. It's all about clarity of what is happening to my data, who's got my data, and in particular, I'm not happy with that particular supplier having my data, therefore I've got the ability to object to it. Yeah, so I would try and steer away from every supplier in the chain sending out similar consent forms. That really is when it begins to break down a bit, and people get very annoyed with the GDPR and why they're being asked to sign all these forms.
Thank you very much, Gordon. Jeremy, I'll come on to your other question in a minute after we've heard from Stuart. I'll go back to the screen because I know you have it. That works. There we go. Stuart, great to have you with us. Thank you very much for being here. You have some significant experience to share, so do you want me to put your slide up first?
Yeah, first of all, let me reflect on Gordon's point and Jeremy's original question. My way of viewing it would be that, yeah, agreed absolutely with Gordon that anybody being asked to sign a form multiple times by multiple partners or multiple stakeholders in the supply chain, that would worry me. That would concern me, like as if the parties are not somehow talking to each other. The critical thing would be that all the way down the supply chain, there are appropriate GDPR and cybersecurity measures in place to ensure that everybody who's touching the data has the right to do so. That would be that, and that probably the data controller would be the one getting permission for the data, because they're the one employing or engaging the subcontractors, the processors and the sub-processors. You reckon, Gordon?
Yeah, absolutely. No,
That's
quite
my view anyway. That just, and the only time we ever, and again, whenever we have a private client, private customer, they then become the client and the customer for me, the client being the corporate, and then we would also consider them to be the data subject, and we would become the data controller effectively and the processor at the same time. But anyway, thank you. That was all I really wanted to say on that point. But I'm here as a storyteller to share my personal experience, for better or for worse. Yeah, I've written that I'm both the victim and the culprit. I was the victim, or rather Interrelocation, my company was the victim in April of 2018. I don't know the exact date, but I can tell you the month. That maybe gives you an idea of how serious this was. We were subject to a ransomware attack. There was an email that came in. It looked genuine. It looked accurate and relevant, and the person in question clicked on the link, and that rapidly infected their computer and then the server. That person immediately phoned their IT provider, external provider, and that company then immediately closed down the server to avoid further infection into any other users from our system who were accessing either directly in the office or via VPN, and then we worked from there. I know all the details of that because the idiot who clicked on the link in the email was me. So yeah, it was me. I'm the one who actually, preaches data security and so on. I don't deliver the training, but I at least arrange it every year. And it was me who got caught out. And I don't remember the email exactly, but without mentioning names, in the last 2 to 3 weeks, I've received 2 sets of emails, both from the actual email address of partners within our industry. These were email accounts that were hacked. The emails that were sent out, I am assuming that the links, the URLs, the hyperlinks within those emails would do something terrible. And thankfully, I hope nobody did click on them. And it was pretty quick that we received an email from presumably the security departments of those companies saying, hey, don't click on the link. And if you have, this is what you should do, which I thought was a very strong, robust response. But it took the point that genuine email addresses can be hacked. So if that's the thing. We always talk about being able to look at an email address, and as long as you look carefully, you can see that's not the real email address. I wouldn't be fooled by that. I was fooled. So that was the point I want to make. Now, what happens to us? We were lucky. We were hit by some lovely Russian ransomware people who, and their ransomware attack encrypted all of our Word and Excel documents. We established that there was no external risk in terms of data. On the contrary, those documents were now far more secure because no one could access them. It was funny, and the story had a happy ending. Why did it have a happy ending? Because we had yesterday's backup. We permanently lost. Again, you should never have documents on the C drive of your laptop. They should always be on shared drives, whether it's a server or a cloud-based system. I had a few on my C drive, so I got into trouble again because those were not backed up. Bad Stuart. Setting a bad example to my employees. But all other documentation that was infected on the server, we had yesterday's backup. We lost 4 hours worth of work that had happened, that had done in the morning. there were a few of my colleagues who were a bit upset with me because they had to redo stuff that they lost in Word and Excel only during that morning. Other than probably not hiring me in the future, but that's not possible because I'm the boss. What's the solution here? The solution was the backup and to check the backup. Well, this links me rather nicely into EGQS Plus, Euro Global Quality Seal, which part of which, at least for us, our business continuity plan, we were told that we should do certain things to test our business continuity plan. And part of that is that once a year I check, and I'm happy to share the details of how I do that, that our backup works. It involves me going into the backup location, which I'm given access to briefly, go in there, modify some files, and then the next day I check the backup. The next working day, I check the backup to see if those documents that I've specifically moved, modified, or both have actually been modified. So I'm looking at a fresh backup the next day. And that has been accepted as being sufficient. EGQS, in my experience, goes some way, and I would say some way, towards a decent, robust, physical data security process in terms of GDPR and cybersecurity. Is it sufficient to cover everything that Ronald was talking about? Probably not. I was talking to a Dutch DSP recently. They hold ISO 27001, and I would love to hear more about that, about how problematic is it to establish that quality system, considering that we've already gone through EGQS, which is quite time-consuming and problematic in itself. And what the particular DSP was telling me is that that has helped them win business, that specifically holding ISO 27001 was enough of a flag to wave to go, yeah, that made at least part of the difference between winning and losing a tender. And then the only other thing that I really wanted to talk about was cyber risk insurance. Several, if not all, of our RMCs certainly say you should have the appropriate insurance, or they may specifically state that you should have cyber risk insurance. I had a conversation with we have general liability, employer liability, and professional indemnity insurance. And I believe the professional indemnity insurance doesn't exclude cyber risks, but it doesn't also specifically include it. And I was told that we should consider having that either separately or specifically as part of that insurance policy. I can tell you it's a real pain. I had a 12-page application form with about 30 questions on each page, which I had the general feeling of if I tick no on any of those questions, we weren't going to get covered. That may or may not be the case. But I felt strongly that the insurance company was trying to set me up that they're only going to give me cover if the chances of them paying out was next to zero. But that was just the cynic inside me. But definitely it seems that cyber risk insurance would be necessary. I can't imagine what would have happened if the ransomware attack we suffered had been one where the data was going to be distributed and could be distributed, and we were held to ransom against that. I'm I guess grateful that it wasn't that kind of attack, but I'm only sharing my personal experience that it's a very scary thing. Oh, and by the way, make sure you tell everybody that's in do disclose as quickly as you can, even if by disclosing like I'm doing right now, you're saying that there is no risk, and we've had that assessed, and we did have an external assessment done, and they said, yep, basically all of your Word and Excel documents are encrypted. even the hackers can't access those documents themselves. They sent in a program that encrypted them, but they don't have access anymore. You're in that respect, you're okay. But we needed to make sure that we close that loophole, that problem, and it can't happen again.
Fascinating stuff and pretty scary. I mean, I remember talking to you about that when it happened, and I think you were the first person I'd ever spoken to who had an attack like that, and I think it made everybody feel really quite vulnerable. I was just going to say, Gordon, when this is quite a few years ago, but do you remember somebody was sending emails from you under euro-relocation.co.uk? And again, like you said, you know, Stuart, there was reason to believe that that was okay. Now, okay, we now own the domain euro-relocation.co.uk, but they were being sent from Gordon saying, I can't remember what they said. It's quite a few years ago, but again, it was the clarity of the message. They knew Gordon's name, they knew our domain, and used it. And our IT people managed to get it shut down.
Yeah, I think it was a funny one, Tom, because I think it was asking DSPs to recommend travel agency services. It was bizarre. And I'm not sure if there was a nasty link in it or what it was about, but yeah, it was completely false, but no damage was done other than me having to reply to lots of emails saying, no, I'm not interested in travel agency services.
It was just bizarre, but like you said, Stuart, that's why I wanted to follow up on that. You know, and Ron, you made the same point. It can look very genuine. It can look real. So a couple of questions. Thank you very much. Oh, two from on the same issue, which is please let us know if IA-based Copilot are safe to use according to GDPR. I don't actually know what Copilot is. Ronald, can you explain that?
Yeah, so Microsoft made a huge investment in OpenAI, the builders of ChatGPT, and that's essentially what Copilot is. It's running inside of Microsoft's environment, and you can subscribe to it. It's not cheap, by the way. You have to pay for it. Microsoft's not going to like my answer, but I would say the answer. Well, there's two sides to it. Is it safe and is it compliant under the GDPR? I'll leave the compliant aspect to Gordon. As for safe, at this point, I would say no. And the reason I'm saying that is because I think it's better to err on the side of caution. Even within Microsoft, some folks were able to use Copilot on information that they did not know themselves they had access to. So imagine the size of Microsoft having tens of thousands, hundreds of thousands of documents in their organization, access controls to figure out who has access to these documents, and employees playing around with Copilot and getting to information that they didn't know they had or should have had. And that's the problem at the moment with AI. Even the developers of AI do not fully understand all its capabilities and how it learns things and what information it gets. So my concern with any, and there's a big rush in our industry, by the way, to doing stuff with ChatGPT, right? Because we were in the middle of a hype cycle and none of us want to be left behind. Problem is, the moment you expose personal data on this, of which we cover a whole lot in our organizations, right? Where does that information go? How do you isolate it from not going back into the language model and therefore potentially running into GDPR issues as a result? So I would err on the side of caution for now, even though Microsoft is obviously sanctioning this and offering it to its customers, because I don't know that we are fully aware of what the impacts are going to be with this.
Yeah.
Gordon. I mean, in terms of GDPR compliance, in a sense, it follows from what Ronald's been saying. You know, if you have any doubts, if you're going to any new technology and you have concerns, you have to address these concerns before you start implementing that technology in your organization. That is a GDPR rule. Now, for something that's a Microsoft product, I would have thought that Microsoft would be incredibly careful that they were falling within the GDPR as they see it. And certainly, I remember, cloud-based systems, providers of cloud facilities, producing materials that went to great lengths to explain why they were compliant, and contracts they'd signed to ensure that the users of the systems would be compliant. So technically, probably they've covered every angle that can be covered, but I would be more concerned at the comments that Ronald's making.
Let me make one quick practical example to illustrate this, right? Copilot helps you, among other things, craft emails. And so back to what we were saying earlier, you don't know inside of email what is personal data and what isn't. Let's assume you have moved two people called John Smith in the span of 2 years. And the second John Smith, you need to respond through email, and you're using Copilot to quickly whip up an answer. Will the Copilot understand that the information embedded in the email from a previous John Smith 2 years ago shouldn't be mixed up with the one that you're writing today? That's part of the problem. It is really hard when all this data ends up in the language model to separate it out. It's perfect for ChatGPT as a concept to get an answer, say, I put something in the prompt, I'm getting something back. But how do you segregate that personal data inside this massive language model? That is my real concern, and why a lot of data security experts are saying, have fun with ChatGPT, use AI, but don't use it on personal data. And how Microsoft does that inside of a system that reads all emails and all documents that are part of the Microsoft environment is a big question. And there are actually lawsuits taking place already, by the way, within Microsoft or against Microsoft for this very reason.
Yeah, I think we can expect a lot of legislation out of the EU and the UK relating to artificial intelligence. There's a lot of stuff going on just now, a lot of legislators scratching their heads and trying to work out exactly what it means in relation to the GDPR, for example. So yeah, let's kind of watch this space, I think.
Fascinating stuff. I mean, we will be, for those of you who will be with us in Villamora, we are focusing a lot on AI because it's a very hot topic at the moment. Our opening keynote speaker, Dan Sodergren, his address is the 5th Industrial Revolution. Do not miss it. Tuesday morning, 11:30. He's a genius. And we've got a couple of other sessions as well going on. Final question from Jeremy to you, Gordon. How do we ensure GDPR compliance across all global jurisdictions where our clients might be relocating? In the UK, we've got GDPR, European GDP, USA, and he believes another 57 countries have their own rules. Pretty difficult, pretty easy to get caught out.
Yeah, I mean, I would say up until now, we've been fortunate in Europe in being able to say, well, the GDPR is kind of like the gold standard. So, if you're GDPR compliant, that's good. And you're going to keep out of trouble, probably. I think, and Ronald would know better than me, but I think a lot of American states are introducing, California has its own equivalent of data protection rules. And as more and more countries and states introduce their own versions of GDPR, we probably will see higher standards coming in some locations. So, I mean, we have to watch out for it. But I would say in terms of being subject to a damages claim or fines, if you are well within GDPR rules, that's still unlikely. But yeah, it's something that could change at any time. China could introduce legislation that set completely different standards and would be quite problematic. I mean, I remember a number of years ago when the Russian parliament introduced rules that all data had to be held on Russian citizens had to be held on Russian servers. So, a few countries introducing new rules along these lines would make life more difficult, put it that way. But so there's not a simple answer. Be GDPR compliant, absolutely. And Euro will advise you if you need to worry about other countries. Well.
Brilliant. Thank you very much, Gordon. So just to bring the session to an end, Oh, just final question, Eugenia, thank you. Are there any good sources that could help to conduct TIA for countries where data is transferred?
I mean, I use a system called Practical Law, which is international and allows me to look at different countries and their systems and their protections or lack of protections. So I can look at that question and see if I can provide a more specific answer. Off the top of my head, I'm not, familiar with a particular system.
So thank you very much, you brilliant gentlemen, for a really fascinating session, which, as we sort of predicted, raises probably more questions than it answers. But we at least, you've provided a fantastic framework for what we should at least be all looking out for. So I'm really, really grateful. Just to bring your attention, those of you who will be joining us in Villamora, Gordon will be running 2 legal clinics on Tuesday and Wednesday over the lunch break, 13 to 1400. The first one, getting paid for your services, avoiding clients who don't pay. There's been quite a thing happen recently, which obviously Gordon will be addressing. And the second one, how to review your GDPR compliance. So that's definitely will answer most of the questions that have come up in the chat box today. So Gordon, thank you for that. Ronald, thank you so much for being with us. And just, I don't know whether anybody realizes, but he did start this session at 7 o'clock in the morning. So thank you very much indeed for a very early start.
My pleasure.
Stuart, to catch up with you. Thank you so much for your candor. Again, I think that's a very human reaction, and it was really good to hear that, because, you can feel pretty lost, and it does happen to somebody who was very honest about it. So really, and Gordon, as ever, thank you for your extraordinary expertise. There's a whole stream of wonderful thank yous coming through in the chat. Like I said, it is being recorded. I'll get that edited tomorrow. Everybody who signed up, 120 people who signed up for today, I will send you that recording as soon as I get the edit done. Everybody else, it'll be free on the YouTube channel within a couple of weeks. In the meantime, I think this is probably a topic we will be coming back to. But thank you so much, Gordon. Thank you so much, Stuart. Thank you so much, Ronald. It's been fascinating. And thank you to everybody who joined. And we will catch up soon. Take care, everyone.
Thank you.
Cheers. Bye.
Bye. Bye.